Solicitor.
Oh, solicitor. Oh, so sorry. Solicitor has to argue. Mr. Solicitor?
Yes, my lord. My lord, I'm extremely sorry once again, my lord. I'm unable to join physically, which I should have, my lord, but I'm still under the bout of some viral, my lord.
Oh,
That's the reason. Otherwise, my lord, I would have
no
been
difficulty.
physically before your lordships, but my coming there would be harmful, my lord, to others.
Yes,
But
yes,
kindly-
Mr. Solicitor.
But please come to page 3. My lord, I'm not repeating anything.
Page 3 of your written submission.
My written submissions, your lordships would find at volume 6. I'm sorry, volume 2B. This can be perhaps one more angle from which, my lord, your lordships can consider the question whether bribery can at all be protected by the immunity or the privilege.
Yes.
And
You are referring to page 3, right? Para 5, Mr.
yes,
Solicitor?
yes, because, my lord, neither the majority nor the minority in Narasimha Rao, but examines the issue from this point of view.
All right. Let's see para 5 onwards. Let's see how you have formulated it.
My lord, I have formulated para 5. It is submitted that the real issue is not the contours of legislative privilege in relation to the parliament or the state legislatures. Rather, the short question on which the present reference can be decided is whether the offense of bribery is complete outside the legislative house. If it is complete outside the house, then, well, your lordships need not be bothered by us as to whether they would be protected, immunity would stand extended, privilege would be granted, etc. Please see, my lord,
But actually, the place, Mr. Solicitor, the place where it is completed, or whether it is antecedent or subsequent to the speech or vote, really should not matter in that sense, because then it will be a fortuitous circumstance. So suppose we'll just give you a hypothetical example. Suppose the agreement to pay a bribe is arrived at within the house itself, may not be beyond the realm of possibility. That then agreement to pay the bribe is the offer and the acceptance takes place within the house. Maybe when some third party is visiting the house for a committee meeting. We are just giving you hypothetical possibilities.
correct.
That's the argument. It makes no difference. So it would not really, in that sense, it should make no difference to the final argument or the legal position in that sense.
No, there is a reason why, my lord, I would.
Of course, bribery, you're right. This is on a very, very strong footing that, well, the offense of bribery is complete outside the house, you say.
Yes, my lord. But there is a reason why I am reading the provisions of section 7 which existed when Narasimha Rao judgment was decided. The reason is in 2018, section 7 came to be amended. The argument in Narasimha Rao is that the performance of the promise for which you took the money would be a relevant guiding principle.
Right.
Whether you voted in favor, whether you voted against it, etc., etc. Lord, if that is the logic, which according to me is a flawed logic, then that gets further, my lord, substantiated. My submission is substantiated by the amended provision, but before
All right.
that, I may
We
show
got it. Now, fair enough. I now got it. Let's see para 5 onwards. We can first read your formulation and then you can maybe explain it to us.
Please, Your Lordship. Para 6. The privilege in terms of Article 105(2) and 194(2) of the Constitution attaches to anything said or any vote given by a member in Parliament or the state legislature, as the case may be. If on a reading of Section 7, the offence thereunder can be said to be complete, independent of and without a reference to anything said or any vote given in Parliament or the state legislature, no question of any legislative privilege being attracted can arise if the member is prosecuted for taking a bribe for the speech or the vote. Now, please see, my lord, section 7, which existed at the time of the judgment. Public servant taking gratification other than legal remuneration in respect of an official act. Whoever, being or expecting to be a public servant, I'm just giving a hypothetical example. I'm contesting the election and I'm promising that if I become an MP, I'll do something for you. Expecting to be a public servant, then accepts or obtains or agrees to accept or attempts to obtain. Now, from whom? Any person. For whom? For himself or for any other person. What? Any gratification whatsoever, whatever, other than legal remuneration. Then for what? As a motive or reward for doing or forbearing to do, either to vote or abstain from voting, either to vote in favor, vote against, or abstain from voting. Any official act or for showing or forbearing to show in the exercise of his official functions favor or disfavor to any person for rendering or attempting to render any service or disservice to any person with the central government. Please note this, or any state government or parliament or the legislature of the state. Lord, the legislature, while formulating section 7, was conscious or at least presumed to be conscious of the provisions contained in section 105 and 194.
Yes.
And therefore specifically makes a reference to parliament or legislative assembly while defining and providing for the punishment for bribery. Not perhaps, maybe this is a little, it can be said to be a little far-fetched, but is it not, I'm posing a question to myself, a manifestation of Article 194.3? 194.3 says that the Parliament can legislate as to what would be excluded from the immunities or privileges. So by incorporating Parliament and legislature in the definition of the Prevention of Corruption Act itself,
Yes.
second ingredients, which is quite startling. Your lordships are aware, but at more than one places the majority in P.V. Narasimha Rao case holds that everything would depend what you do out after you go inside the hall of parliament or within the parliament, whether you vote, you do not vote, you vote as per the promise given, etc. But here, performance of that motive or reward for which you were paid bribe is not an ingredient at all. The moment I accept or agrees to accept or attempts to accept or obtain, the crime is complete.
Yes.
So performance, my lord, which is an underlying ratio in the senior, in majority view in P.V. Narasimha Rao case, is absent.
Yes.
Similarly, at page 4, I have placed for your lordship's consideration section 13 as it existed then. Again, performance, what you do, is irrelevant. Your lordships are right, but in many cases, it is quite possible that the agreement takes place within the house. But in extraordinary cases, even the acceptance of money also can take place inside the house. But your lordships would not, interpret the provision based upon
the place at which the bribe is given.
Yes, and some extraordinary circumstances. Suppose one MP hands over a bag containing 2 crores to another MP inside the hall, that you vote up in a particular way. Quite possible, but it is one out of 1,000 possibility. Generally, we go by the Prevention of Corruption Act, the way in which bribery takes place. So your lordship's interpretation may perhaps not be guided by extreme examples.
Yes.
Now, if your lordships, my lord, can ignore, my lord, there are some judgments, my lord, which analyzes this provisions. But please directly come to the amended part. My lord, thereafter, I have quoted the minority view of my lord Justice S.C. Agarwal. Your lordships have been taken through this, my lord. I don't think I would be justified in reiterating or reading, my lord, the whole thing. Your lordships may kindly directly come to para 16. Now, this is amended section 7. I'm sorry, page 16. This is amended section 7, where the performance, which is not the underlying ratio in the majority judgment, is specifically excluded. But does your lordships, my lords, my lord, have section 7?
Yes, sir.
This is section 7 of 2018 amendment. Please read, my lord. Any public servant who obtains or accepts or attempts to obtain from any person an undue advantage with the intention to perform or cause performance of public duty improperly, his intention, not that he will perform, but it becomes further clear. When I pay the bribe, my intention is that somebody would either perform something or will not perform something. Improperly or dishonestly, or to forbear or cause forbearance to perform such duty, either by himself or by another public servant, or it is disjunctive, or obtains or accepts or attempts to obtain an undue advantage from any person as a reward for the improper or dishonest performance of a public duty, or for forbearing to perform such duty, either by himself or another public servant. So my expectation is that you will perform or not perform. But for the purpose of completing the offense, that performance is not necessary. That is becoming clear in explanation 1. But before that, I must read C. So after two disjunctive expressions or, please see C, performs or induces another public servant to perform improperly or dishonestly a public duty or to forbear performance of such duty in anticipation of or in consequence of accepting an undue advantage from any person. These are 3 separate categories of offenses.
Yes.
Now, my lord, it is made exceptionally clear in the explanation 1, immediately, my lord, following subsection 6, C. Explanation 1. For the purpose of this section, obtaining, accepting, or the attempting to obtain an undue advantage shall itself constitute an offense, even if the performance of a public duty by public servant is not or has not been improper. Suppose he goes inside and discharges his duties properly, but he accepts the money. But my respectful submission is that the connection essentially, my lord, established in majority view of Narasimha Rao as to how you perform your part of the bargain is irrelevant for the offense of bribery.
The majority does not specifically dwell on this at all.
It does not refer to at all.
Actually, it was the minority. Justice Agarwal says that, well, the offense of bribery is complete the moment that there is an agreement.
Para
So
52.
that's not the correct view, but this is completely what happens is the majority
Majority
says
did not deal with it at all.
at all.
Nor did the majority say that unless there is performance, there is no bribery. They don't say to the contrary also.
Not so.
Yes, but when they say that unless there is performance, there is no bribery.
Right.
Not runs
That's how
contrary,
they, all right.
may perhaps not run contrary to the act itself. That's the respect.
All right.
Lord, para 15 on the page 17. But that's exactly what your lordships hinted. But interestingly, on the aspect of the offence of bribery being complete outside the legislative house or parliament itself, even the majority view holds the same. The majority view, to the extent it holds that prosecution against Sri so-and-so would continue, thus on the sole understanding that the offence of bribery was complete outside the house itself and does not require a vote in the house. Then, Lord, I may not read, your lordships have read and reread the provisions. I'm just not taking your lordships through what we could find out to assist your lordships. I'm not reading it, my lord, because now the way, my lord, in which even the petitioners have argued, so this may not have any direct relationship, because it's nobody's case that there need not be a privilege or immunity. Everyone says that there has to be. The only question is whether bribery can ever be protected under the privilege or immunity. Nature of parliamentary privilege, your lordships are aware. I am not reading it. I have quoted several authors, etc. Then page 21, need for the privilege. Your lordships are aware, to ensure that I vote, I exercise my rights and perform my duties freely and fearlessly. That's, my lord, in one line, the object of the privilege. Then your lordships may directly come to the position in India at page 24 at the foot. I am not reading it, my lord. We have gathered, my lord, various provisions, and my lord, for example, page 26, Government of India Act 1935 had similar provision for immunity and privileges. My lord, that was section 28 of the Government of India Act. Substantially, my lord, that is adopted in the Constitution. But I am not reading it, my lord. Then your lordships may kindly come to page 29, case law on privilege. But whatever judgments are delivered so far, to our knowledge, there may be few which we may have missed, are quoted, relevant provision is quoted. If your lordships would like to go through them. Then, page 33 is position across the world. We have try and call out, the position across the world. Again, my lord, for this limited questions which your lordships are examining, my lord, this may perhaps not be relevant except, my lord, some academic interest. Then, my lord, 37 is Chetan. My lord, this is the judgment, my lord, I would respectfully rely upon. But, my lord, I'm told this is also, my lord, read before your lordships. Do I read it, my lord, or I may not trouble your lordships? But I think I should not trouble your lordships.
Which one were you saying, Mr.?
My lord, page 37.
37.
R versus Chetan.
Later, I think we have looked at, yes.
The lordships have, my lord, seen that. So I have just quoted the relevant paragraphs for ready reference. But I don't think, my lord, but my lord, at the foot of page 39, there is one paragraph 246. Now, this is the concurring view in Chetan.
Yes.
But 73, not 246, 73. A little later, the report considers the dividing line between matters that fall within the type of parliamentary privilege and those which fall outside it. This lies at the heart of these appeals and merits quotation in full. This quotation is the concurring view in Chetan. Takes the same view, but in a different phraseology and different language. But that also, your lordships are taken through. But there is no much development in America after the Narasimha Rao judgment. That's what we found, subject to the other side pointing out anything new. There is virtually none. Then, page 42, voting or speech in parliament is the core parliament activity. Your lordships are aware, my lord, may not be a matter of contention. Nobody would dispute this proposition, but the judgments, including Raja Rampal, I have quoted, but as your lordships have very rightly and kindly pointed out that your lordships are not going to revisit that, my lord. Therefore, I'm not troubling your lordships. Then page 45. But this, my lord, as a proposition of law, my lord, would be very, very relevant because self-regulation is essential ingredient of separation of powers. All the three. Basically, your lordships are aware, parliamentary privilege is essentially against the crown, against the executive. But the law which has developed or evolved is that all three organs of the state would have the right and power of exclusive self-regulation without any interference by the other. In other words, my lord, the independence or self-regulatory power of parliament is as sacrosanct as, my lord, independence of judiciary or independence of executive. But that's the, my lord, judgment on this. Then, my lord, page 46, examples of exercise of power by parliament itself. Now, this may be of some interest to your lordships. Of course, this may not assist your lordships in arriving at any conclusion on the question on hand. But whatever examples we could find out in India, that how this power of self-regulation is utilized by our parliament. So those examples are cited right from my lord Mudgal case. Mudgal case, my lord, then cash for votes case, where, my lord, some MPs came and threw some bundles of money, etc., etc. But I am not taking a loss because this is more, my lord, for my lord, some other, my lord, academic interests rather than assisting your lordships. Then, my lord, again, I am emphasizing privilege as a concomitant of separation of powers, but your lordships are not examining the concept of privilege as such. And therefore, my lord, I am not reading any of these judgments, my lord. Then, my lord, development of the law on privileges again from the narrow compass of bribery vis-a-vis privilege, my lord, may not have much assistance. But since your lordship said that whatever research you have done, please place it so that your lordship gets everything on one page. But that's what we have done.
Yes.
So this is my respectful submission, my lord, that bribery can never be a subject matter of immunity. Unless, of course, my lord, if 1 out of 1,000 cases, my lord, takes place within the house. But my lord, this is not examined. This angle is not examined either by majority or minority. So, my lord, this is, my lord, just for your lordship's kind consideration. Instead of, my lord, declaring Narasimha Rao to be not a good law, the lordships may have an option of saying that it is per incurium because it does not take into account the statutory scheme of the prevention of corruption.
Yes.
And performance is irrelevant. And the offense, which encompasses all its ingredients, does not include performance. And when everything is outside the house and the offense is complete outside the house, there is no question of privilege being claimed or immunity being established as a defense.
Yes.
So these are my respectful submissions.
Thank you, Mr. Solicitor. Thank you.
My apologies, my lord, and grateful my lords permitted me virtually.
Thank you, Mr. Solicitor. Yes, Mr. Ramchandran.
Yes, once briefly, please. Firstly, minutes, apropos an observation from the bench about not speaking, not voting. I respectfully, minutes, bow down to that observation and respectfully agree, minutes, that the immunity must extend not just to speaking and voting, but also remaining silent and abstention. And in this context, kindly bear in mind, bullets, that when you are voting on the floor of the house in a modern house, bullets, there is an I button, there is a no button, and there is an abstention button. So an abstention is also a vote given. And the significance of an abstention also, whether it is in the matter of a vote of no confidence on which the survival or otherwise of a government depends, or in the only known case in our constitutional history, Millards, of impeachment of a judge of this court. It's the abstention which made the difference, Millards. And there, of course, it was a whip of the ruling party. So the ruling party en bloc abstained. But in a given case, an individual abstention or 2 or 3 abstentions could make the difference, Millards. And so, if such abstention is also made culpable, it would definitely be in respect of a vote given. And therefore, Millards, by respectful concurrence, Millards, with the observation which came from the bench, Millards.
Yes.
Now, Millards, as far as the learned Attorney General's submission is concerned, he says, Millards, that the judgment in Narasimha Rao's case, the majority, takes a guarded view. I haven't understood the attorney's submission as saying that the majority is wrong. I understood him, and that is why, Millards, I took the precaution in my main argument of addressing his argument on why Narasimha Rao is not attracted. The Attorney General's argument is only this, that voting is not legislative. And I would reiterate, it is legislative for an additional reason which I am going to give. But otherwise, the Attorney General seems to be ad idem with our submission that the guarded view in Narasimha Rao deserves to be preserved. The Solicitor General's argument, Millards, is concentrated on the offense of bribery being complete. And that is the argument, Millards, of the learned amicus and the interveners led by Mr. Shankar Narayanan. Now, Millards, that argument begs the question of what does in respect of mean. Yes, there can be no doubt that the offense of bribery has been committed at an anterior point of time. But if it is in contemplation of the vote, notwithstanding the criminality, the link with the future vote brings it within the umbrella of privilege. Notwithstanding the anterior criminality.
Yes.
Today, Millards, 2 of the learned counsel for the interveners, Mr. Shankar Narayan and Mr. Hansaria, made a reference to hate speech in the context of the recent hate speech. Now, Millards, I am fortified in my argument by that example for the reason, Millards, hate speech. Let us take that hate speech example, Lordship.
Mr. Ramchandran, if the ingredients of the offense,
Lordship, please.
the citus of the ingredients of the offense is in the speech itself, then then it is immune. Then the immunity is attracted. We are not on the morality of it or whether it is proper or improper. But if the offense lies in the speech itself.
If it was only in the speech, yes. But
Now, suppose you're right now you are in you're on your legs. You say something about your opponent, or you say something about a community. All right, that speech itself is the offense. That is immune. That the speaker of that speech is therefore clearly immune because that is a matter of privilege.
absolutely. But I'm not on
You are
the
now saying
citus.
that irrespective of the if the antecedent criminality, if the vote is a consequence of the antecedent criminality, then that itself also is within the ambit of the
Lordship, please.
privileges
And
and
for
immunities.
that, Millards, I didn't complete that hate speech example. Of course, Millards, if the citus is the hate speech itself, but there can be an anterior event even in respect of a hate speech. A hate speech need not be necessarily a spontaneous speech on the floor of the House. There
There
can
may
be
be
an
a bribe
example
given in
of a
there may be a bribe
pre-planned.
in consideration of a hate speech which is made on the floor of the House.
There can be a pre-planned
Yes.
conspiracy. There can be a pre-planned conspiracy.
But then the
among-
prosecution is not for the hate speech, but for the bribery, which was the
I'm sorry.
underlying feature of the hate speech.
I am on the offense of conspiracy, which is an offense by itself. It's a conspiracy to commit a crime. Now, therefore, if MP X 5 days prior to the sitting of Parliament has a meeting in his constituency with 3 or 4 of his constituents, that let us put these people in their place. I'm going to say this, and I'll say it in Parliament. Let's see what happens. Nobody can do anything. And as in pursuance of such a conspiracy between an MP and his constituents, it is decided to therefore make that speech on that occasion because of the immunity. The offense of conspiracy is complete 5 days earlier because they have conspired to commit a crime. Therefore, how far do we then go in attaching criminality? And Millards, the submission which I made, which I reiterate now in this context, is that you can't, Millards, bifurcate criminal offenses and say we are talking only of bribery, don't touch anything else. Bribery, no, it is not just bribery which has an antecedent element because the physical act has taken place before. Any other criminal act can have an antecedent element.
If the act in this
That's the proviso to 128.
Yes, Millards. It's section of IPC. Lordship, please, my lords. Or, as Justice Narasimha, my lords, just observe, my lords, defamation. So, someone's character is to be besmirched. So you agree among yourselves that I'll say it in Parliament. What is 120A, my lords? Let's see the definition, my lords, of criminal conspiracy. When two or more persons agree to do or cause to be done, one, an illegal act. So let us take 153A, enmity between different groups. So
Ramchandran,
an MP and his,
you are trying to read something into this provision which we don't find it there under. Scope is totally different. That is what we are trying to tell you.
with respect, no, my lords,
105, it deals with a right of a member to have his freedom of expression, speech, and to vote.
Lordship, please.
That right is recognized, number one. We recognize as the right if he exercises his right by way of speech, by way of voting. The consequence also protected. While doing that, the parliament has got its own privilege, how to deal with it, like we can expunge it, or we can
Expel
he
the
can, he
member.
can do, say, expel him, or if the vote is invalid, it can do that. Now, where is the question of criminality coming here? That is it.
No.
The protection is very limited. What is happening within the house? I think we are trying to make it much more wider, which is not even under the provision.
My lords,
See,
by,
now the privilege and this has been given to maintain the sanctity of the house. All right, anything has happened here, please don't take it out to the street. Nobody else should be able to deal with it. Now, what is happening otherwise? What way, see, we are not able to decipher anything under the provision, whichever way you like to read it. Whatever the interpretation you give, let us give a simple interpretation. What is the objective behind this?
and
Nothing
therefore,
beyond that.
therefore, my lords, my submission is that we are going away from that simple interpretation if we try to say that bribery is anterior, offense is committed, and for that I am drawing an analogy with this, that if you conspire to defame, if you conspire to commit hate speech, which is anterior, and then go and commit it in the house, then by that
But
logic,
if the defamation which is to take place is on the floor of the house,
Lordship, please.
then the act of defamation itself is immune from any prosecution.
Lordship, please.
In such a situation, can the conspiracy itself become actionable under 120A?
Because 120A, let us see. So let us see the definition. Let us see the definition first. When two or more persons, agreement,
Agreed.
Just agreement.
It just says agreement.
Just
But agree to do,
120A is agreement.
agreement.
but agree to do what? An
Let-
illegal act? Now, if the agreement is to make a speech in parliament or the state legislature, which is going to be allegedly defamatory, that act itself is not illegal because that act is completely within the scope of the immunity. The speech itself is protected.
No, I'm sorry. Can I just read out the ingredients of the section and my lords respond to my lord the Chief Justice? When two or more persons agree to do or cause to be done an illegal act.
Here. The essence or the element, the critical element is the agreement. Once there's an agreement, that itself, the offense is complete. But the agreement constitutes an offense if what is intended to be done is an illegal act or an act which is not illegal by illegal means.
Lordship, please, my lords.
So if the act which you are going to, two people sit in the house of a member of parliament, or five people sit in the house of a member of parliament and say on this day, at this point, he or she is going to make a statement which is defamatory. If that statement itself is not defamatory, or if it is defamatory, it is within the protection of Article 105, then clearly it's not a conspiracy within the meaning of 120A then.
But on the other hand, those who entered into that conspiracy with him, first the conspiracy is hatched consciously to go and make that speech. So on the one hand is the defamation contained in the speech, but anterior to that is the conspiracy to commit
Defamation.
defamation
But it's
or
the
hate speech under
But there is
153A.
no conspiracy to commit a defamation because there is no defamation on the floor of the house.
I'm sorry, Mirs. The conspiracy is to
You
defame.
are saying that the conspiracy is independent of
Lordship,
the
please.
actual act, the
Lordship,
actus reus.
Lordship, please. The conspiracy is to defame individual X. The conspiracy is to
Anyway,
make
we are
a
really on
hate speech.
hypothetical. We are really on a hypothetical, but I'm not sure you are entirely right on the interpretation because the act itself is not illegal. There cannot be a
My
conspiracy.
submission is the act is illegal if you conspire to make a hate speech or to defame and then go ahead and do it.
Mr. Ramchandran.
And that hypothetical example has to be given because now we are trying to stretch this to the fact that bribery is anterior. Therefore, it is necessary, Millards, to illustrate the fallacy of that approach by giving this contrary example.
It would depend on the nature of the offense.
Lordship.
So far as, I'm not expert in criminal law, but my friend, so far as conspiracy 120A is concerned, agreement which is illegal itself is sufficient as a crime.
Lordship, please.
Nothing more need to be 120. There are judgments saying that. So therefore, prior to the participation in the parliament, if an offense prescribed is complete at that point of time, then you can be prosecuted. On the other hand, take the example of defamation. Defamation is complete on the happening, the effect of it on the reputation of the person. Though there is a conspiracy prior to the proceedings of the House, eventually the offense comes into place only upon the utterance in the parliament and the effect of the utterance of the people. There in that cases, then the immunity perhaps attached. But in 120 case, 120A that you are talking about, the offense is complete in the type of a conspiracy before the proceedings have commenced.
In other words, the House is not concerned with the conspiracy per se. It's concerned with the effect of the conspiracy, and that will take care of the decision to be made. When it comes to conspiracy, if it constitutes a criminal offense, then the law will be set in motion. So the House is concerned with that offending part of the speech or the vote, and the resultant action to be taken by it. Only to that extent it will take note of the conspiracy. To that extent it will find fault with the speech made or the voting made. Only for arriving at its own conclusion. That will not take away the role of the prosecution agency in a case where a criminal an offense is made out. 105 is not meant to be protected as such a contingency. The idea is to maintain the sanctity of the House. We can't stretch it too far to say that what has happened earlier, if even assuming a offense is made out, then you should not, immunity will apply.
Conspiracy is
Lordship.
punishable in itself, correct?
That if the offense of bribery is in contemplation of a vote to be given in the House or cast in the House, this brings it within the
Protective
ambit, the protective ambit of privileges and immunities, notwithstanding the anterior criminal.
Lordship, please.
That's your
Lordship.
that's the formulation.
Lordship, please. Now, Millards. And therefore, also my submission, Millards, which is part of this, that you can't therefore make a distinction between different types of criminal offenses because always conspiracy, abetment, etc. are also offenses. And therefore, we can't say we are only looking at bribery because it's shocking our conscience. We can't compartmentalize it. Anything which is criminal is criminal. That's how we have to view it, Millards. An attempt was made to remove defamation from the criminal law.
To Parliament.
Wait.
That part of
Yes,
the
but
majority
that
judgment is to be diluted.
That doesn't affect, because it doesn't affect
Therefore,
my
this
case.
first proposition you're giving up there, because we
I'm-
need to dilute the majority judgment.
Because the first
At
proposition
least on
is
that count.
the first proposition is in the context of my submission of relating to the facts of my case, because a vote
But on
was
this
given.
count, it needs to be diluted. That because the majority
Whether
judgment turned on
Ajit
that.
Singh,
Speech made, not made.
Lordship, please, Lord. So,
Ajit Singh is let off because there was no speech made.
Lordship, please, Lord. So I am
that logic
happy.
would have to go now.
I am happy if Ajit Singh had also got the protection, Lords. To that extent, by my agreeing,
To that extent, the
by
judgment
agreeing,
also needs to
I'm
be
only
modified.
happy with that the late Ajit Singh. I
To
wish
that
the late
extent, the
Ajit Singh had
judgment
got
needs to be
protection.
modified, Mr. Ramchandran.
What happened to
To
Mr.
that
Ajit?
extent, it needs to be modified. The judgment needs to be modified.
please.
That
Lordship.
logic would have to go.
Lordship, please.
So
Lord.
your first proposition goes.
I still don't concede that my first proposition goes. My first proposition may be refined. My first
That needs to
proposition
be
may
diluted.
be refined.
Your first proposition needs to be diluted.
What happened?
Needs to be refined. Needs to be nuanced. Needs to be nuanced.
By the way, does anybody know what happened to that prosecution of Mr. Ajit Singh thereafter? What happened actually, in fact?
Those are
Uh,
only for,
bribe
all
givers
these
were all
files
acquitted.
down only to academic discussions in the court. In reality, what happens, God only knows.
As far
Bribe
as
The bribe givers were acquitted.
Bribe givers were
Were acquitted
Oh.
because the
Lawyers have the last laugh.
Yes, but
The guru of acquittal,
or the Jain Hawala case, Milords, ultimately what happened to the prosecutions, Milords.
But
Yeah.
there is no escape from PC Act, Ramchandran. There is no escape
Now,
from
Milords,
PC Act.
my second point, I'm making basically 3 points in my rejoinder, Milords. My second point is with regard to Parliament and House of Parliament, Legislature and House of Legislature. Because my Lord, the Chief Justice today emphasized a different aspect of it. Because 1052, as I had also pointed out in my submission, uses legislature in the first limb and House of Legislature in the second limb.
So what is the second submission?
My submission is that the significance of this distinction
Yes.
is not only what my Lord the Chief Justice emphasized in his observations earlier in the day, that House of Legislature authority pertains to what is published outside. That was the emphasis which my Lord the Chief Justice laid.
Yes.
But this distinction is also important in the context of my submission that voting as a member of the legislature for the Rajya Sabha election is a vote given in the legislature, though it is not in the house of the legislature. And let us not, Milords, and therefore, Milords, the submission of the learned Attorney General is misplaced when he, with respect, contends that this is not the kind of vote which is protected under the immunity. I pointed out Article 80 of the Constitution. As an MLA, it is my constitutional duty to vote. It's an integral part of my duty as an MLA to vote. And let us not look at this only from the point of view of an election of an MP or two to the Rajya Sabha. Voting in the legislature and in parliament as against in the House of Parliament also happens in the presidential and vice presidential election. That is also not done in the chamber. It's done in the lobbies, minutes. And your lordship will recall in 1969, a president of India was elected as a result of a conscience vote, where minutes, as against the official candidate of a ruling party,
Mr. Giri, VV Giri.
Mr. Giri became president.
Neelam Sanjeeva Reddy was the official party.
Was the official candidate. Now, therefore, voting, this vote, whether it was my client Sita Soren's vote for an Rajya Sabha MP X, or whether it was a Congress MP's vote for VV Giri or Neelam Sanjeeva Reddy, they are both of the same character. These were votes in parliament, these were votes in legislature. And Millards, the same protection must arise. My reason for emphasizing the presidential and vice presidential poll is that these are not just stray Rajya Sabha elections.
There is a vote there.
Lordship, please.
It may not be strictly necessary to.
And finally, minutes,
Yes.
finally, when I contend before your lordships to take note of the majority's caution that this can be misused, that passage in Justice Bharucha's judgment, which I read out minutes, it is not something alarmist, mere possibility of misuse. Mere possibility of misuse is not something which I appreciate the courts will not countenance, because the courts are there to protect. But the possibility of misuse, going back to Blackstone, Blackstone is not quoted by Justice Bharucha, but the same thought is echoed in Justice Bharucha's judgment, is the very basis of privilege. Misuse of the criminal law, inter alia, apart from other law, is the historical basis of privilege. And therefore, if your lordships keep that in mind, your lordships are not surrendering to the forces of fear, but your lordships are only recognizing the historical and constitutional basis of this particular privilege we are talking about. I'm grateful. Yes.
Thanks, Mr.
And as I've already said, we have a strong case on merits for reasons which we have set out in our written submission. Yeah.
Very good.
Grateful.
But appearance is not for the judgment.
Very good.
Grateful.
Thank you very much for your assistance. Thank you, Mr. Attorney.
Deeply
Thank you, Mr.
grateful.
Patwalia.
Very
Dr.
good.
Narayan,
For a very pleasant
Ramchandran.
hearing, Manoj, from.
Thank you very much for assisting us. All the interveners and the juniors also. Thank you very much.
Thanks to the amicus.
And the amicus. Yes.
Very good. Very good.
Mr. Solicitor also, thank you.
Done.
Attorney as well. Thank you.
Very good.